Okay. Good morning, afternoon, late afternoon, everyone, wherever you are. Thank you for participating in this fourth BELS bi-monthly meeting. At this occasion, we have Jacob, who will lead the talk on a piece he's working on diverse value of nature in the court and how court materialize or give form to these various value. And this recognition in the court does not only have an impact beyond courtroom. It also impact the policy making process and also send a broader signal to the society. So I'll give the floor to you, Jacob.
Thanks, Rika, and thanks everyone for coming, especially I know everyone's very busy. This is a long-suffering paper, and because several of you have contributed to it or participated in conversations in the past, and it's really one of these suckers that sticks around for a long time, but it is finally moving. But apologies to those of you who have been involved that it is not yet in publication, but it will be one day, and it'll be worth the wait, I promise. And so this is, as you know, very much a work in progress. And you know, some colleagues have contributed to it from BELS and from other groups, and you can see some of our working titles. The idea about the relationship between courts and diverse types of values. And I want to present this to you so that something to chew on. So please argue with us. Because it's still very much in development. The starting point for the proposed paper is that we know that we have diverse values for nature, right? And this is work from the Intergovernmental Biodiversity and Ecosystem Services panel, and a lot of this led by Unai Pascual, who some of you might know is one of the leading environmental economists, heterodox environmental economists interested in diverse and plural and relational values, and he led the writing on chapters, the values chapter for IPBES, and has agreed to come on as a co-author on this paper, bringing in that insight. And whatever we call them, plural values, diverse values, relational values, we know that, and increasingly across fields, sustainability, environmental economics, law, conservation, we recognize that, you know, the importance that we place on nature is obviously not just instrumental, right? But it's also then, you know, we've said, okay, well, there's also provisioning services and maybe cultural services, but still the framing is often very, very quite instrumental. And increasingly the argument is that this isn't just about diverse values that we might have for nature. It's also about diverse ontologies and ways of thinking about space. And particularly for nature, the non-commensurability and the non-fungibility of a lot of these values. Right? Things like mitigation banking have assumed that you can chop down a tree here and plant 2 trees over there and somehow they're equivalent. But so many, and for certain ecosystem services and values, that's true. Carbon, for example, maybe. But for sense of place, for identity, for food culture, for religion, for knowledge, for mental health, that they're not fungible in that way. And so the question is, how do we reflect these values in our policy processes? I just want to give a quick anecdote of that. Rika and I spent a lot of time with Indonesian judges, and one in particular, Ibu Nani, Rika, we're talking about how hard it is for judges to understand these kind of intangible values. And I said, Ibu Nani, do you have grandkids? And she said, yeah. I said, does your grandkid go to the park sometimes? She said, yeah, of course I do. I said, well, how much money is that worth? And she said, well, it's not about money. I said, but your grandkid values it, so surely you can put a dollar value on it. And so, that kind of opening up and that realization of this very economistic thinking, limiting our understanding of really our human nature relationships. And of course, her values, the way she understands values really matters as she's making her decisions. So there's been a huge amount of effort, primarily by environmental economists and sustainability scientists, to think about values and how valuation, use of economic tools to understand values, usually through monetary terms, but not always through monetary terms, to inform the policy process. The argument being, if we can better understand these values and reflect them in qualitative, quantitative, economic terms, then we can somehow feed them into the policy process. And so this is a, kind of the traditional, very linear, totally inaccurate policy cycle, right? Where we, set an agenda, and then we develop a policy, and we adopt it, and we learn from it, we implement it, we learn from it, this iterative process. We know, of course, that policy is not this linear, but it's a convenient heuristic. And Pasquale et al. Argue that for too long, we have only used narrow economic cost-benefit analyses to think about these things. And then actually we can use values, more plural relational values like the ones I've described, to inform policymaking at all these different stages. It can help you to inform a decision through awareness raising, to decide which of these policy options might be important, to design a project, to evaluate a project to see whether it has met our, collective societal goals. And so they're arguing we have tools that allow us to understand plural values, relational values. Let's use them to inform policy. And, we do have cases of this happening around the world where we don't only just use economic instruments to make these decisions, but you'll notice in their heuristic, there's something kind of mysteriously absent, and that's law. There's, there might be law kind of as an implicit tool in these different stages, but it's not something that they have considered as a instrument that might inform the use of values, or more diverse non-economic values, into this policy process. So that's kind of the starting point for us. We're writing for an environment, sustainability, conservation, non-legal audience, for whom law probably means catching bad guys and jailing them, right? One of the things that I've come to realize, thanks largely to engagement with you all as a non-lawyer, is how legally illiterate the environment community is. We really, both when it comes to concepts and theories of change and kind of what law can do, and then of course procedures. Again, I started a talk at Cambridge years ago saying that my understanding of law comes from Hercule Poirot and CSI television shows, right? It's so basic and rudimentary. But in fact, I think we need to argue to an environment audience that actually law matters in lots of different ways, and we need to articulate a little bit about why. So the next move in the paper is talking about both what Rosenberg calls casual influence, and extrajudicial influence. Laws can force you to do things. Yes, they can punish, but they can also force you to do things, to review laws, to compensate and remedy liability, right? And importantly, all these extrajudicial impacts, the legal expressionism of sending signals to society. And that has knock-on impacts, of course, on individual offenders, on future offenders, but also on bureaucracies, on companies, and on the public at large. Now, you will know better than I do that these outcomes and these impacts of legal actions are unpredictable, inconsistent, as we're learning, very damn slow and frustrating and incomplete. But, across contexts, we see that they do affect stock prices. They do raise issues to the public mind and of politicians. So the argument is law is not a silver bullet, but it matters. And if we come back to this heuristic of how values diverse values for nature can inform the policy process to make the world more sustainable, the question is, well, can law back these up? So we've added on some preliminary triangles to we added yet another layer of circles to their circles. And in this, we're saying, well, if we start from the right, valuation to design and intervention, we said, well, legal action can force you to design a project in a way that recognizes diverse values. So for example, an environmental impact assessment says that you have to consider, social and environmental impacts. Does it consider plural values? Can a legal action force a consideration of more plural values? Deciding, can there be legal actions that might compel a certain action or challenge an existing decision if the decision wasn't made in a way that considered plural values? Can we force them at this later stage? C, can we stop, amend projects that fail when we're informing these policy implementation? Can we come in midterm and say, look, your dam might be, the hydrological impacts might be acceptable, and that was reflected in your EIA, but it's actually having these downstream impacts on a community that is affecting certain types of, I don't know, cultural or religious or sense of place values that were not considered. And so we need an amendment to that project, or we need an injunctive relief. Now, if we move on to C, or what should be D, I don't know whether these are separate or linked. There's also evaluation to inform the policy evaluation. Did it work? Whatever that intervention was, did it give us what we wanted? And actually, this is where liability litigation might come in, and we'll say, no, it didn't, and you failed to correct it, and now we're going to sue you. And then, of course, at the very top, D, there's also this idea of valuation or plural values to help inform for agenda setting, which, of course, is both at the beginning and at the end of an intervention, or throughout the life of an intervention. And this is where these extrajudicial impacts of legal action might have an impact of raising public awareness or changing behavior. So the idea is here just to try and illustrate that law has a role. I originally started by thinking about liability, that being my focus, our focus. But of course, the legal tools that are available to us are far broader than that. And I think they have quite natural analogs to these different steps in the policy process. So then, especially thinking about the fact that I'm speaking to a non-legal audience, I started thinking about, well, we can't write about judicial review to an audience that doesn't know what a judicial review is. And if we're trying to argue that a judicial review can influence values that's going to give us sustainability, we kind of have to take a step back and almost offer a primer. And so I developed this heuristic for myself, and this is at a point where I'd especially appreciate your thoughts on it, because I was trying to organize my thoughts. What are the different types of legal action that could exist in that policy process, and what could it give me? What sort of remedy or resolution that would promote plural values could it offer? And so this is a non-lawyer's best attempt at a taxonomy that seeks to, from what we've learned across many jurisdictions, seeks to simplify it for a non-legal audience, which is, of course, always hard because so many countries are different. But this is our best attempt to show different types of categories, baskets of legal action, and the types of remedies, the rows that they might be able to offer. So, injunctive relief. We can secure injunctive relief, let's say primarily, well, we can secure it via an administrative order. We could also secure it via civil liability litigation. And if we think about how can civil liability litigation secure an injunctive relief remedy that is relevant to values? Well, you could sue to secure a stop to a project that is harming, certain types of diverse relational values. What about, let's move down. What about criminal prosecution and remedies to correct harm? Remedies to correct harm, I think, was option C along the process, right? When we're evaluating. Well, civil liability litigation can give us remedies to correct harm through a liability suit. It could be a liability suit seeking an apology or seeking an investment into a cultural fund or into a public education activity that seeks to correct harm that has already happened to diverse values. Equally, we might be able to secure that via an administrative order, right? The first column. That could be because in many countries we've got administrative orders allow agencies to, without going to the courts, to seek remedies for actions that have caused harm, and so on and so forth. Issuance of additional rights, things like rights of nature, for example, that might recognize broader ontologies and broader sets of rights and broader standing, could be secured through civil liability litigation or judicial review. The point here is to show that there's redundancy in the system. There are different types of legal actions, and to kind of almost offer the menu of types of remedies that are available that could be relevant to values. Now, we then started to break up these different green triangles that we added on. And we recognized that if we accept that these are the broad legal categories, and there's still some discussion as to whether these are the right buckets, well, what are they within them? Well, if you're looking at policy formulation step, you might take action to require that in that policy formulation, they formally consider diverse values when they're going through that process. Well, you might be able to do that through different ways. you could seek a judicial review, for example, to require that the EIA process consider certain types of values. Or you could consider equally a judicial review or a civil liability suit that is expanding standing and giving rights of nature, legal personhood to wildlife or to a river, that would then require a policy formulation process to consider plural rights. Or you could just take a non-strategic legal action, and we've got lots of examples that are expanding standing. For example, the right of an NGO to represent the environment. That issue of standing could be within here, and it would, by expanding standing, would expand the different types of values that can have legal recognition. Excuse me, and so forth, and so forth, so on and so forth, for policy adoption, policy implementation, evaluation, and agenda setting. We're just thinking about examples of the main types of legal action that might affect. And then we've started to populate that with examples, and I've just picked two here. So legal standing, in the first column, we've got policy formulation, legal actions that result in securing recognition for diverse interests. Here's an example. This is, of course, a famous Philippines case where it wasn't just a claim on behalf of current generations, but the Oposa case was also saying there's also harm to future generations, and that the court recognized the decision was that the set a precedent that their intergenerational rights need to be recognized, and that future generations also have legal standing. Unborn generations have legal standing today. So the question is, well, what does this say about rights? And of course, it even though in this case, actually, it was quite explicit, intergeneration, it's not just the current generation, but future generations have a right to a balanced and healthy ecology. This has huge implications in terms of policy formulation and agenda setting, when it instructs us to think about different time horizons in our policy setting. Here's another example. Legal action seeking an injunctive relief or an amendment to a project that is harmful to certain plural rights, certain diverse rights. This is a case that Rika came across from Japan. So priests from a shrine challenged a road development. It was a road development for tourism, a road expansion. It was going to cut down 15 ancient cedar trees, including one that was over 500 years old. And it was spared specifically because of its importance to legend, to folklore. And the case and the appellate, and on appeal, it was held up. And it said that in the balance of tourism development for this road and of cultural values, actually, there was a requirement that they should put great importance on conservation and on cultural values. So these are very explicit examples where more plural values were reflected in court judgments. So now on to the points that we're aiming to discuss, and we're still kind of muddling through this because we've been working so much on the front end of the paper. But one of the things that's come up is that in those two examples that I gave you, the recognition of rights or recognition of plural values was quite explicit. But one of the interesting things is that as we look through cases, often these things are not explicit, but they're nevertheless implicit to the logic of the judge, to the logic of the ruling. And as part of that, it's because some of these cases are very strategic or the claim is very, very clear. But in other cases also, the recognition of diverse value sets is perhaps an unintended but important ancillary benefit. And so we want to talk about different mechanisms by which diverse values can be recognized, standing explicitly, like in the Japanese cedar tree case, but also things like orders to apologize, right, which have very low monetary value, but can have very high significance nonetheless. But then we wanted to spend a little bit of time talking about the challenges to reflecting these diverse values in court decisions. And of course, that's things like economistic thinking, this idea that the intangible cannot be reflected in court values, that we know it's important, and yet for some reason judges aren't smart enough to figure it out. I don't know. But importantly, to spend time focusing less on complaining about the fact that this is hard to reflect, because we don't actually think it's that hard to reflect, and spend more time proposing solutions. And of course, Amanda, this is where things like species victim impact statements come in, but also prosecutor and judicial education, which, Rika spends a huge amount of time on, for example, trying to explain to judges and prosecutors that this isn't that hard and that the law doesn't limit it. Case databases, which of course, I think as many of you know, we're working on putting together a database of cases that reflect diverse types of remedies so that we can show one another. This isn't, you know, the tree cedar case is a great example to be able to show to judges from other countries, perhaps, particularly in the absence of large case law. And one of the things we know is that even though we know about these cases isolated, and there's a lot of case databases, there are none that we've been able to find that address these types of issues of remedies. Learning across jurisdictions, strategic litigation, amicus briefs, things that can help us to think about the fact that we don't just need to think about compensation or economic cost-benefit analyses. An issue that Suryon, I believe, raised a long time ago when I first discussed this paper with him, and it was in very different form. Suryon, correct me if I'm wrong, but I think it was you that was really highlighting that the law is not just about the claim or about the outcome, it's also about the process. And particularly if we're interested in diverse values, things like whose voice gets to be heard, where the court is located and who can get there, who has access to information. There's also the procedural aspects that if we're interested in values and being more plural, we also need to consider. And then for conclusions, we're thinking again about this idea that it's not all about outcomes. Often cases, in particular the public or journalists, were concerned with what happened and did we get what we wanted. But we know that change is not always, again, strategic, not always planned, and not always derived from court victories. It might be about, you know, training judges and prosecutors about what's possible in incremental change. A lot of law, as we know, is very tedious and slow, and that's okay. That's, you know, that's also, law is meant to be slow, right? Judicial policy is fast and law is slow. But I think also then a conclusion that I'd really like to draw, because it's been so much part of my experience, is around this idea of legal education for the environment sector. And there's so many people writing about plural values, but there's so much less in the environment, but so little about law and plural values. So kind of hitting that as a point that might be able to advance. And again, not a silver bullet, but kind of glaring that the IPBES that talks about all these policy levers misses what is the most perhaps obvious and ubiquitous policy lever, which is formal legal frameworks. So that's the quick and dirty of it. Oh, hi, Paul. I don't know if everyone's met Paul, who's a relatively new colleague who's been really, really helpful to thinking about these things and has been, yeah, battling back and forth with me in the last couple of months, and bringing in some case law from Australia as well. So yeah, that's it. Let's chew into it, please.
Thank you, Jacob, for a short introduction of the piece that we're working on. We will be very happy to hear your comment or feedback on this piece, or even if you have any interesting cases that you would like to share to complement the database, it will be very helpful as well. Is there any?
Or also, or if Paul or any of the other folks who've been working on this want to add in any points that you think are important that I've missed as well, please feel free.
I think there is one thing that I would like. I just realized this few weeks earlier because one of the reviewer of my separate paper asked about this question. One thing that I didn't realize is that many of the, especially in Indonesia context, many of the good judgment that accept different kind of value come from civil litigation. But then we miss to understand that the civil law or private civil law is originally designed for a private interest, which is so economic interest oriented. So that's, I think, one of the explanation why when we talk to the judges, they still try to put all of this diverse value into a private law framework, because we do litigation in civil liability framework. And it will not work because the value that we talk now is not private interest value, is public value. So fighting for public value in a private law framework will have that kind of gap that need to be bridged. So that's one of the things I think is also interesting to be discussed, and I would like to hear your opinion on it as well. Because I read some scholars are pushing more on public law to address public interests, and then some judges also think that pushing public interest in a civil private framework will disrupt the legal doctrine. That's why when we see some judges reject for example, when the case asked the court to compel executive branch to issue certain policy, because then the court have this kind of fear that it will blur the line between judiciary and executive power as well.
Your comment makes me think, Rika, of the recent environmental torts decision in the Philippines, which was a kind of explicit recognition that we're using an old tool for new purposes, and explaining very clearly that that is okay. And so even though it's not well rehearsed yet in the Philippines, that verdict our colleagues in the Philippines were highlighting was really important for that reason, because it was so explicitly translating and saying this tool that we used to use for private, economic interests can also apply in this broader context.
Right. And I think it's important to make it explicit that this is a new thing and we have old tools. So we understand that to keep insisting on this old tool without modifying it will not answer the current problem, because the old tool is not designed for this value at the beginning of its creation.
Can I just make a quick point here?
Yeah, go ahead, Paul.
Sorry I was a bit late there, Jacob, but yeah, you gave a great demonstration of the work, so thank you. Yeah, that stuff about tort is really interesting, because the use of tort in an environmental context has been tried in Australia, a case that a number of you might be familiar with, the case sort of colloquially referred to as the Sharma litigation. Now, what was interesting about that case is some comparisons. The case ultimately failed in the federal court in Australia. However, there were, of course, parallels drawn to the Agenda case in the Netherlands, which also used a duty of care type argument. Interesting in Agenda, though, is once it got to the upper levels of appeal, the duty of care argument was sort of taken over by more of a human rights argument. And in Australia, there is no real human rights legislation or Bill of Rights or anything, instrument of that nature at the federal government level. So the argument perhaps failed for those reasons. If indeed there was a human rights instrument in Australia, I think we might have seen a bit more success for that duty of care argument in Australia. So I think it's interesting that when we talk about using existing or old, sort of so-called older instruments in law, particularly Jacob said that were designed for a different purpose, we have to also be mindful that there has to be sometimes a combination of these uses. So it could be tort and human rights in conjunction. So I think that's a really interesting point that I think in jurisdictions, going back to that last slide that Jacob had up there and was talking about, I think, transnational law or different jurisdictions or whatever. I think that's a really interesting point there as well, because those particular jurisdictions where the rights instruments are stronger will have much more opportunity for these sorts of cases to lean into those arguments, be it rights arguments or a rights adjacent argument. So yeah, those things are all interesting. I think targeting places that have those rights instruments, I think strategic litigation was mentioned there as well, is a key part of strategy. So yeah, it's a lot of really interesting stuff. But the thing about all of this, right, all this litigation that's been greeted with all this success, it really requires, I think, a lot more analysis, because there's so many bits that I think the radar when we have the standard sort of analysis. Like you take so much of so-called climate litigation, and yeah, the issue is primarily climate change, But when you look at the success rate of some of these, especially strategic climate cases, really, how is it that the plaintiffs are demonstrating the impacts of climate change? They're doing it by and large through biodiversity impacts, impacts in terms of extinction, impacts in terms of degradation to environment. But that important element of biodiversity is not being foregrounded in a lot of the analysis of these cases. And I think if you could feed that into these, plural values of nature, I think then it would give a much stronger understanding of how important these different values are to the argument and to the strategy of some of this litigation that we're seeing. Yeah, sorry, that was a bit of a long point. Sorry, but yeah.
Thank you for any other comment or feedback or something that just interesting to discuss, come up with when we discuss this topic.
I thought it was very, very interesting. And the thing that I constantly see in judicial approaches to dealing with pluralistic values is, whilst they are, at least in my jurisdiction, and certainly in China, of course, as well, receptive of them, they always go back to the framework. And so they go back to CITES, they go back to whatever the piece of legislation is that they're enforcing. And of course, I'm only talking from the criminal perspective. And they don't seem to feel comfortable becoming more creative with recognizing these harms. And I think that's because of the anthropocentric approach that they're taking to the way they resolve crime. So I wonder if, when I was looking at the slides, and you've probably thought of it already, sentencing guidelines is an important place to attack as well, because sentencing guidelines, of course, do tie the hands of judges in those jurisdictions where they're allowed to have them. And the US sentencing guidelines, of course, are a problem because they're not taking into account as much as they should be of these other types of values. And there's even case law that suggests they shouldn't take it into account, but that can be addressed. It's just a matter of getting to the policy people when they're doing it. Edinburgh, for example, is rethinking their criminal penalties for wildlife crime. And so that's an opportunity to talk to them about what they put in as far as what they consider harms are in wildlife crime, to get beyond this idea that it's just where you hit in CITES or whatever other framework you're looking at.
That's an interesting point, because Amanda brought up about the criminal law approach, and to connect it with what Paul mentioned earlier, that the creativity is needed to accommodate this value, but it's kind of limited in criminal law approach. But several countries nowadays have additional penalty that acknowledge ecological loss. And sometimes in Indonesia, we recently have that, but have not been utilized. So sentencing guideline to show the prosecutor that you can do more than just fine and imprisonment will be a great example. And also we have interesting cases from Italy. Maybe Jacob can also share about that we will have a webinar next week that show the combination of this criminal and then liability approach, where we can use the liability part to push for more value in a criminal court. Jacob, do you want to share?
Sure, just a quick plug, and some of you have probably heard because I've spammed you via email and LinkedIn about the case that we had in Italy, where we had a win a couple of early last month, and this was a case of illegal cactus trade from Chile into Europe, and in that there was a criminal prosecution, and we recruited a plaintiff to bring forward a private civil suit conjoined into that criminal prosecution and found them pro bono lawyers and so on. And had loads of problems getting the lawyers to even vaguely engage with anything that was kind of, again, more creative. Even our lawyers were not super adept or willing to entertain things. But in that, and under one Italian framework, that we were able to seek moral harm, is a term that's used in Italy and France and some other countries. I find it a very lazy solution to the plural values problem, but that's essentially what it is. It's recognizing that you created harm that is non-economic, and we want to recognize it. So in that respect, it's actually quite cool. It's a cheat. It's a shorthand for, and etc. and everything else that I don't understand, but I know is there. What we did specifically, though, was rather than pick just an arbitrary amount in our claim, we specifically said, we have picked an arbitrary amount in our claim, but we are going to use it for the following remedial actions. Unfortunately, the judge's verdict does not say, and you shall use it for the following actions. He's just said, and there's compensation for this amount for moral harm, that bucket. But for us, this is still nevertheless really important because it moves us towards a discussion, including in the wildlife context and biodiversity context, about the fact that, this is not just about finding someone. This is actually about broader harms and the potential for remedies. So the plug is that next Wednesday, at this same time, I believe, no, a bit later, and Rika will send it out to BELS if you haven't all received it already, with an invitation to that webinar on the 19th, so a week from today. We'll have a Chilean prosecutor on it. We'll have the very eccentric Italian plaintiff, someone from the IUCN and so on. So if you're available, it'd be great to see you there.
Thanks, Jacob. And also to link with the sentencing guideline, I know some people here work on sentencing guideline. Marcia probably can share, because in the coming project, I shall also plan to intervene with the sentencing guideline of Indonesia prosecutor. That guideline, because we in environmental law, we have additional penalty in form of restoration, and the previous guideline already talked about that, but then it didn't accommodate the new additional penalty of restoration in the conservation law. So probably Marcia can share a little bit about the sentencing guideline that you've been working on with the prosecutor.
Yeah, thank you, Rika. Hello, everyone. I'm Marcia from Indonesian Center for Environmental Law, also lecturer in Criminal Law Department of Faculty of Law, Universitas Indonesia. So we've been working with Attorney General offices, developing guideline for environmental case handling. The first one is kind of general guideline, and we also have not really a sentencing guideline since it's for the prosecutor, but we set a guidelines on how and when they could use the additional penalty, such as the restoration, and put the company in guardship, so they wouldn't breach. So they wouldn't violate any environmental offenses, meanwhile restoring the damaged environment. But also we are developing sentencing guidelines for wildlife conservation crime, probably this year or next year, because it's kind of challenging for them to use that law, because it's still a new law that is enacted last year, and it's currently being the restoration penalty is only for the corporation, but we are trying to stretch that corporation definition for the organized crime, for the criminal organization as well, so they could use that for preparators that is not a corporation, but they do it in organizedly. But I think that's all that we can share. Rika.
Thank you, Marcia. I really do. There are a lot of potential in optimizing criminal law approach that in some country also accommodate remedies. Any other comment or question?
May I ask a
Oh, yeah.
question, Jack? As we know, the different countries have the different interpretation of the value of nature in legislation. So my question is, how these strategies you used to deal with the transnational cases, for example, the smuggling of the catchers, you try to cover as much as more values of nature in the court.
So you're asking about in transnational cases, what values can be reflected if it involves more than one country?
Yeah,
Is
yes,
that-
yes.
I guess my kind of very bureaucratic answer would be depends which of the countries you're bringing the case in. Because that's the judge that's the prosecutor or the plaintiff, the legal framework, and of course the judge. And one of the things that we're learning is that, of course, not only are the legal procedures very different, but the socio-legal context is so diverse, right?
Yes.
I don't know if that answers your question, but I think that is interesting. One of the things that we were, several of us, Rika and I from this group were in India early last month with plaintiffs from 6 or 7 countries. And we were speaking with Indian environmental lawyer, and we were talking about apologies as a remedy. And he and his colleagues thought we were crazy. They thought we were not only crazy, they thought we were stupid. Is that fair, Rika? They just... Now, this isn't to say that Indian law doesn't allow it. It's to say that it's not culturally salient. But we know, and there's been studies on this in other contexts, places like Japan, a public apology is incredibly important. In Germany, and culturally important. In Germany, public apology is incredibly important to business profile. Now, those are actually 2 contexts in which a public apology, a public statement of wrongdoing is culturally important, but probably for very different reasons. In Germany, and I mean, I'm assuming, but I guess, excuse me, that also gets to the fact that just how cultural law is. And particularly when we're talking, again, we're starting to talk specifically about remedies, but of course, we're also talking that values can be part of the EIA process, part of the judicial review process, not just the liability process. Law is usually silent about these values, or they're there, but they're implicit, as Paul has kind of reminded me many times, even in the verdicts. And so if they're not explicit, your procedural judge, as you were saying, Amanda, or the prosecutor going back to the letter of the law is not going to engage them. Or if they do engage them, it's going to be because it's culturally meaningful to them. And our Indian colleague was just like, what are you guys talking about? But in other contexts, it matters. So I think that that's a really interesting lesson.
Okay, thank you.
I suppose one of the things that I'm a little bit self-conscious of when we're talking about these things also is that as a non-lawyer, I look at this and I'm like, I think this is quite novel, quite interesting, and like the matrix of different types of, very simplified descriptive matrix of different types of legal action, different types of remedies. But on the other hand, I'm also like, don't you all learn this in the first year of law school? Maybe this is completely, redundant. And I'm curious whether specifically that heuristic, but also kind of the broader line of argumentation is interesting, or if it's just kind of like, yeah, we know this. Or maybe we know this, but we don't have it explicit and we need it explicit.
Yeah.
Sorry, I can chip in. I think for me, it's actually helpful to, like, we know that the remedies exist, but I think it's very helpful to have it kind of categorized like that and seeing what different values are at stake and how certain remedies may be more appropriate for certain values. So yeah, just a very quick short point, but Yeah, I think we know the remedies that exist, but I think for some very conventional harms, the remedies are well established also. Sorry about all the traffic noise in the background, by the way. But for something that's relatively more complex or novel, like environmental harm and also multifaceted, I do think it's helpful. But then I've also sort of been involved and had like very minor inputs on the paper. So of course, like my takes may be somewhat colored by that. But yeah.
No, your confirmation bias is very welcome, Suryan.
Thank you, Suryan. Yeah, go ahead, Laina.
Yeah, thank you. So thank you for this presentation. It's very interesting. I've been working with the values of nature and impact assessment, and I've been doing my postdoc with Munai. I'm still working with him. So I'm very familiar with this side, and I'm not at all familiar with the law side. Everything I know from the law side is from Rika. So, but I'm still don't really understand what this value of nature framework can bring to the legal side. Because I think something is missing there in the conversation is that the values of nature is all about including more voices. So whose voices are we listening to? And so it's not values, abstract values in the sky or in a book or something. It's really, that was at least the genesis of sustainability science, right? Is how to include more voices, especially marginalized voices, on voices from minorities or into the debate, right? Into the policy making process and so on. And then I'm still not sure how do you do that from in your paper? Because for me that's the main point. How do we make voices heard in other spaces? So yes, but I might misunderstand the very fundamental point. I don't know.
No, I think it's a fair point, actually. And one of the things, and there's papers on this, is that legal action is highly centralized. You know, if we look at Indonesia, how many NGOs are bringing environmental legal action, and whose voices? So there are biases in that, right? Even traditionally there's huge biases because the state is the one who brings legal action. But in other countries we have broader standing, including particularly around public interest litigation, scientists, NGOs, the river itself, depending. And in a lot of countries, that standing is much broader than it is in Europe or than it is in US, Australia. So that's one thing. More people have the opening to the table. But there's still fundamental barriers to access. Money, power, a lawyer, right? So I think that there are still these kind of political economy questions that obviously influence that. And I think that's something we need to,
But then how does this framework in terms of value of nature would solve this issue? Because I think that's
so
a much older issue.
So we're not using a values of nature framework in the way that rights of nature is kind of known as a thing. We're using a much broader framework. Rights of nature, I mean, specifically things like legal personhood for a river or for a species. We're talking about that's one of the options, but there's a much broader set of options. The way it addresses it is, for example, recognizing a case that recognizes that an NGO can bring a claim to the court on behalf of the public interest in nature, for example. And that NGO could be an indigenous peoples organization. It could be Rika representing, or a scientist representing a public interest in the environment. It could be a community doing a class action suit, bringing a case themselves. So I guess part of it is by, a large part of it is by, the answer is that broadened standing is what I would say. But let me pass it on to others to see, because maybe I'm thinking too narrowly as well.
Yeah, I think it's interesting when Laina says value of nature is about how more voices heard, and it's, I think, directly linked in the legal problem is who has standing, because who has standing mean who can represent that voices. If no one can represent or claim that voices, then it will not be heard in the courtroom. And looking back to the problem of many of the cases, we use a private law framework, which is originally intended to address individual harm. And nowadays, in many countries, they try to use that old tools or what Paul mentioned before, combine it with the new tools to say that we will not just hurt a private interest harm here. We will hurt also a public dimension. Or for country that acknowledge the right of nature, they separate it's not just public dimension only, but it's also the nature itself that has standing, regardless of their public value of the nature. So for me, especially interesting when we talk about how to make more voices being heard. It's linked with first, how can these voices access the court? That then linked to the legal standing, and then how can we hear voices to know what is the best remedy that can be provided? Because in the old tools that we usually have, the court has a tendency to think that monetary payment is the best remedies. But then if we pass the mic to the other voices that you mentioned before, we could expand our horizon on remedies that, for example, for indigenous people, sometimes apology is important. Sometimes certain ritual or certain action is more important than just paying some money. So that's especially what I can get here. Maybe Valerie or Francesca or Adrienne can add, or even Amanda.
Okay, can you hear me?
Yes.
Yes. So first of all, thank you, Jacob. Thank you, Rika, for illustrating this paper. I find in general very interesting this idea of enlightening at least the legal scholars that there is a connection between remedies and values. And I think this is a bit, especially for lawyers and judges, this is really, really important. I actually had very close questions to what Lena, I hope I pronounced correctly. Yes, something more about how to operationalize then a very complete value framework in the remedies. And I think this is a crucial question, which, as Jacob mentioned, is also depending on the country. So you can imagine something perfect, but then depends on the countries that are there. But yeah, in general, I think the idea should not be compromised by the practice and what is available there. I still have some issues when we talk about standing, because even if we allow a larger standing, still groups might be biased, or I still see the possibility of a conflict of interest in even in NGOs, or it's not always the case that we have an immediate protection of the interests of nature in organizations, through organizations or public agencies. So it's the same. So maybe something to also mention is how to imagine a mechanism to prevent these conflict of interest then. But okay, this is another conversation. And I was thinking when the remedy is restoration, which is happening also in Europe, and not monetary compensation, are you also including in the paper a kind of analysis of how to do restoration in a way that all the values of nature are included? This is a question that also comes from the recent nature restoration law. So it's, how to achieve full ecological restoration then.
Not within this paper, simply because of scope and space. But one of the things that actually we have been working on, and this is at a request of practitioners, is a highly, very unsatisfyingly simplified framework to developing damage claims in environmental cases. Excuse me. And the idea there is including aspects of well-being and relational values. The problem that we have, one of the many problems that we have, is that as soon as we start having conversations of the nature that we're having now, we lose 90% of the practitioners. It's just not going to happen. And particularly where we're looking, for example, in a place like India, to really mainstream the idea of remedies and compensation into something that is almost a little bit proceduralized. Discussions about, diverse ontologies just is not going to get a place at on the table. So we're trying to think actually of some very, again, frustratingly oversimplified frameworks that would allow a practitioner, prosecutor, potentially a private plaintiff, a judge, to go through and say, what are the types of harms that I might consider? What are the types of analogous remedies that could be appropriate? And this is hyper generalized, hyper simplified, but it's our attempt to, one, make things usable. The original damage claims, God, Rika can tell you, the original damage claims that I was working on are so far from the types of damage claims that we're working on now, because I was looking for truth rather than practicing law. And so there's a dance there. But the other thing is, because the judges and prosecutors are unfamiliar with this approach, they don't, now the idea with developing this resource, and we're going to publish it through the IUCN, is that they will no longer have to take the word of Rika or some private interest lawyer or some prosecutor to say that this is a legitimate approach to thinking about diverse types of harms and more plural values. The idea is that it's some sort of an official outside resource that they can draw on to back up their approach to damage claims, because the law is usually silent, because there's so little case law, and because these sorts of values are usually, if they're addressed, they're implicit rather than explicit, and this will help to reveal them. I'm very conscious that it's going to be imperfect, but yeah. Your other point about standing and kind of bringing it forward, I completely agree. Yeah, I guess it's just about, if we can increase the number of cases and diversity of cases and diversity of people bringing those cases, and thus also the diversity of values that they are representing, maybe we start to move towards a more plural, sustainability oriented. But the biases are going to be for sure. And I think we have to acknowledge those, like explicitly in the paper as well.
Yeah. And Francisca, you're also welcome to give input for that IUCN totally simplified framework that we're working on. Probably we can send them out, Jacob, for a comment.
Absolutely. We're working on a first draft of it, but it'll be open to public comment through IUCN, through BELS, and we will definitely be nagging you. In fact, it's not it's not only that you're welcome, you will be coerced, gently coerced.
Yeah.
Just to make sure that we have plural values.
The last part, when Francisca mentioned how to ensure restoration include all the relational value, I'd like to hear Valerie comment on that, because you work on ELD a lot. Is there any practice where restoration is not just about ecological resource, but also the relational value with the community around?
Yeah. Oh, thank you. This is all very, very interesting. Thank you, Jacob and Rika and everyone. Yeah. I really don't have anything much to add. I'm just looking at various little bits. I don't know if you all are aware of a law in Wales, the Wellbeing of Future Generations Act. It's the first in the world. It's not got many teeth. Has it really been a success? Probably not so far, but the various the legislature, the various public authorities, etc., in Wales have got to consider the interests of future generations in what they do. And then just on a completely different track, in the EU last year, there was a revised environmental crime directive. And the old environmental crime directive didn't really work. The commission looked very carefully at it, did an impact assessment, etc. And they found what it was intended to do. It took 9 violations. For example, one would be, say, destruction of a protected habitat, etc. And it said under EU law, those had to be criminal. Because there's a difference between administrative penalties and criminal penalties. Administrative penalties basically limited to fines. And the administrative agency is the decision maker in those. Now, when you get to criminal penalties, those are judicial. So there's a big difference between those two, and it harms the reputation of somebody much more if they are, say, convicted of a criminal offence, which is an offence convicted by a court. Anyway, what the revised Environmental Crime Directive did, it took those 9 offences and made increased them to 20 offences. So a lot of now offences against the environment have now got to be criminal in the member states. In addition, what it did, it increased the fines, increased the penalties, and also added a new accessory penalties. So and it recognized ecocide for the very first time. And the accessory penalties, for example, it will maybe require somebody who's convicted of one of these criminal offences to remediate the environment. Or it will say they can no longer stand as a director or an officer. And it's also looking at especially the directors and officers of companies and saying they now can be liable as well. So that is something that really increasing the kind of remedies that you can get in criminal law to include remediation remedies. And then something that entirely different again, there is a French law of prejudice ecological prejudice, and it's in the civil code. I have tried for many, many years to really understand it, and I don't. But it lets NGOs, for example, as well as public authorities, bring lawsuits for compensation, and it includes moral compensation as well. And it's for their loss in biodiversity. Is it really successful? I don't, as far as I'm concerned, no, I don't think so, but I think I'm a bit prejudiced about it. I don't, for example, people are using it in France, instead of the Environmental Liability Directive. I don't think it is as powerful, for example, but for example, one very big case, and I know that you all know about this because you had somebody from France, I can't remember his name, at a seminar quite a few years ago, who gave a presentation on it. It was in the Calanque, Parc de Calanque, in the south of France. And there had been, I think there were 5 men, and they had been fishing in protected areas in the Parc de Calanque, and they had been capturing and killing these rare fish. and they then sold them to restaurants and fishmongers in Marseille. And they were convicted of doing this. And in addition, as well, what there was an action brought under this ecological prejudice law, but the amount of the fine that they got was then reduced by the Court of Appeal, massively reduced, and then that was upheld by the French Supreme Court. So but that is putting together kind of administrative law and tort law, because it's under the civil code. So I've explained it very badly because I really don't understand it very much. But I don't know if that's useful.
Thank you, Valerie. Yeah.
And I'm sorry, I've actually, this is very personal, but my dishwasher broke and the men to replace the dishwasher have just drawn up in front of my house. So I'm going to disappear in a minute.
Okay.
Sorry.
Yeah. Francisca, before we close, I see
Yeah,
you.
I was actually remembering a case also from the south of France where after a damage, I read about this case and this was really interesting, but they were adopting a different remedy because the damage was actually polluting a protected area. And this was somehow for me interesting to realize that when there is an overlap between liability and conservation law, so protected areas, as exactly as Valerie was also talking about, maybe administrative law, but this somehow brings the interpretation of values in a different way. In the remedy that you adopt, that the court decided to adopt. And there is more to say, because then in that case, for example, there was also the insurance taking part, and again, drawing things, the remedies to another direction. But yeah, I actually think that if we reason about remedies, also this overlap of laws is very, very interesting to take into account, depending on where the damage actually is occurring.
Thank you, Francisca. That's definitely sum up our discussion. Yes, there are many legal tools available to accommodate that we can use to try to accommodate all of this value. So maybe if it doesn't work in criminal law, then maybe it work in civil or it work in administrative. And it's very interesting also to learn various practice from all the participants today. Thank you so much for your time. And if you have other like paper or topic you want to discuss with us, or you have a deadlock or something that you want to discuss with the BELS community, please let me know and we can set up the next bi-monthly meeting to discuss about this.
I would also invite, if anyone says, I really want to be on this paper and I'm not yet, and you have time in the next couple of months, because it has been, as I alluded to at the beginning, too long. Please feel free to just drop me an email directly.
Okay, thank you. We will be waiting for your comment and feedback. Also, I will be very happy if somebody says like, I want to discuss about this in the next BELS meeting. Thank you so much. Have a nice morning, afternoon, and night.
Thanks so much, everyone. Lovely to see you.
Thank you, everyone.
Doors are closing.
Thank you. Thanks, Rika.
You. Bye-bye.
Okay.